very rainy day. And I hope, even though we weren't together last month, I hope people had a chance to participate in some of the really great Pride events that happen across our county and obviously across the state. And, I wanted to start a little bit by thinking this week we both celebrated 4th of July. And then yesterday we had the opportunity to be with some of our interns at the Supreme Judicial Court. And we were talking a lot about John Adams and the Declaration of Independence. And obviously, the principle contained there, quote, that all men are created equal, which started America's journey towards equity and inclusion. But as I'm sure many of you do when you hear that phrase, obviously for me, it leaps out that we've left out women. It leaves out that we've left out people of color. We left out enslaved people. And that work continues. And there's a lot of work to be done. And we talk a lot about the fact that America's greatness comes from its diversity, and it's the richness of people who've come to our country that help to make it what it is. But as we all know, sometimes in practice, that is a bit more difficult, and we've seen that. And and many of you have heard me say this before. I think part of my job as district attorney is always to be thinking about how do we reduce the number of people in this very diverse county who ever wonder if they belong. And to that end, I've been spending a lot of time working with legislators on bills that will clarify and strengthen the laws that we have around hate and bias. And we're going to talk a little bit about some of those bills, and don't worry about the numbers or writing down all of that, because we're going to put all of that in the chat, and we'll email them to you as well in the follow-up notes. I also want to thank the folks who came to the International Day for Countering Hate Speech on June 18th that we had at the State House. And we co-sponsored that with Representative Priscilla Souza from Framingham, and wanted to highlight the impact of the hate speech and bias motivated incidents and some of the legislative efforts that we're making to address that. And the first piece that we talked about was House Bill 1995. And that bill espouses a couple of things we've talked about so many times here, primarily education. Right now in Massachusetts, if someone is convicted of an assault and battery with intent to intimidate based on some characteristic of the person they've intimidated, as part of that disposition, they must attend and complete a diversity awareness program. That's good, and we know people have found that to be helpful. But there's a balance, right? Many times we have worked hard to limit the impact of the criminal justice system on people, especially young people. So, for instance, you have a young person who engages in this kind of conduct. We want to change their conduct. We want to hold them accountable. But we don't necessarily want to give them a criminal conviction that they're going to carry with them for the rest of their life. So we might think about things like a continued without a finding or pretrial probation or some other alternative disposition. And that can be very useful. But right now, a judge is not required as part of one of those dispositions to include that training piece. And we would like that to happen. So when we give someone the benefit of one of those kinds of dispositions, we would like them to be engaging in that same training program. This bill would require judges to do that unless they made a specific finding that for some reason it wasn't warranted in a particular case. So it's really kind of a common sense piece of legislation that blends a lot of our important values. A second bill is House Bill 1589, Senate Bill 1056. Many of you have heard us talk about that before. That corrects what I believe is really just a mistake in the legislation. Right now, if you have had property damaged as a result of being targeted for who or what you are, that you must be the owner of that property. in order to be a victim in that case. So for instance, if you are a tenant, you obviously don't own the door or the fence that might have been damaged. If you are a college student and the door to your dorm room is damaged, you don't own that. So right now, either the college or university has to be willing to be the victim. Your landlord has to be willing to be the victim. I think it's just a simple mistake. When they wrote the legislation, they forgot to make that inclusion. And the second piece, which I think is clearly also an omission that was unintentional, and that is if someone is convicted of these crimes and they're ordered to pay restitution, because the victim might become somebody else, there's no requirement that that victim use the money to mitigate the harm. So for instance, you're a tenant, your landlord is willing to be the victim, so we're able to prosecute somebody. The person gets convicted. There's an order as part of the disposition of that case that the person, for instance, repay the $700 it would cost to repaint what was damaged. That $700 goes to your landlord. He might have some other financial need that is not fixing the door, and he's not required to use that money for that. One of the places that's been a particular problem is a city or municipal building gets damaged. So for instance, I live someplace, there's a town building across the street from me. Someone paints some kind of hateful things on that building facing my house. Person's prosecuted, restitution's ordered and paid, and the town needs to be doing some road construction. And that's what they use the money for, rather than repainting. So this bill would fix both of those things. And the third section of legislation we've been interested in is House Bill 1675, which is coupled with Senate Bill 1246. And those bills would extend the protections of being a victim of a hate crime to people who are targeted because of gender or sex. And it would clearly define those as hate crimes. And, having this day at the State House working on this legislation is really a piece of our recognition that as community leaders, which all of you are, it's important that we be using our platform, no matter how big it or small it may be, to support our neighbors who may be more vulnerable and to take a stand against targeted hate. And so many of you do this already, whether it's organizing a peaceful community event, holding a virtual discussion, offering an educational series that's helping people to learn about a diverse culture. Those are the efforts that really foster understanding, connection, and making communities more inclusive. The opposite of that is we know that those, especially with political power, who use divisive language or promote a discriminatory idea, it really has an outside impact because it legitimizes within a community prejudice and those feelings of otherness, and it can encourage people to engage in this hate behavior. And we know that when that happens, when there's been a divisive election, a divisive political event, it encourages these incidents. So today we're going to focus on some specific laws to protect individuals' identities and the federal impact of the current administration's executive orders. And we're going to especially talk a little bit about some of our schools. You may have seen the Globe editorial today talking about the problem of anti-Semitism in schools and how it can be addressed, places that have been effective in addressing it, and communities that have really faced some challenges. So I'm really happy to welcome with us today Adam Cambier from the Attorney General's Civil Rights Unit, who will give us an update on current laws that support the LGBTQ plus community. We know that some of the actions of the Supreme Court lately have led to significant changes. They've impacted protections that previously existed against bias. And Adam is really going to focus on how that could be affecting schools. And as I said, Adam's an assistant AG in the Civil Rights Division. And if you're not familiar with it, the Civil Rights Division at the AG's office really addresses a broad array of anti-discrimination issues, whether it's in housing, employment, the criminal law, immigration, healthcare, all of those issues. And Adam's practice in that unit focuses on issues affecting the LGBTQ plus community. And a significant amount of his current work is focused, as you might imagine, on ensuring the protection of people's right to gender affirming care. Before coming to the AG's office, Adam practiced commercial litigation at WilmerHale and clerked for Justice Young of the District Court for the District of Massachusetts. And you can read again about Justice Young this morning, reminding folks that he took the change of plea from the shoe bomber a number of years ago. The protections, some of the protections, I guess, or the rules that went into place about taking your shoes off at the airport are ending today. And one of the things I was reminded when I read that was that when Adam Reed, that individual, was sentenced, he kept insisting, sort of self-promoting what he had done, saying that he was a soldier for freedom and all of that. And Judge Young reminded him that in every courtroom, there is the flag of the United States, and that the flag of the United States would be there long after he had been forgotten. And that he was reminding him that he was not truly a soldier of freedom. So it was just interesting to see that all back again today. And Adam knows that piece, I'm sure, of Judge Young's history well. So Adam, thanks so much for being here with us today.
Thank you so much, DA Ryan, and hello to everybody. And thank you also for the ode to Judge Young. He's the best, like an incredible judge, and also just like the nicest guy in the world. So I appreciate the chance to come and speak with everyone about LGBT rights. So this presentation is going to give sort of an overview of the protections that exist, and I think towards the end we'll touch on some of what's happening in the federal landscape. Let me start the presentation, and then we'll see if I can get that to share. Share. There we go. Can everyone see that? Yes, great. All right. So we'll start things off just with a sort of a quick introduction to what the Attorney General's office does. So as DA Ryan already shared with everybody, I'm in our Civil Rights Division, but we do a ton of work across a really wide array of legal areas. There's the Consumer Protection Division does a ton of work. We combat fraud, we combat corruption. There's an entire criminal division that deals with criminal violations. We have environmental work, labor rights, all sorts of things. Honestly, I've been with the office for 4 years, and I still have like a pretty tenuous grasp sometimes of all the things the office does because it's such a broad scope. But generally what we do, there are sort of 4 buckets of things that we work on, particularly in the Civil Rights Division. We investigate issues that are brought to our attention to the extent necessary, bring enforcement actions in court or potentially in other fora. We try to conduct prevention activities, including giving Know Your Rights presentations like this, trying to educate the community about what rights they have and educate sort of the larger community in terms of businesses, schools, things like that, what their obligations are. And we work in policy, trying to help guide policy through the legislative process or things like that to help move civil rights in sort of the right direction. We have 4 offices across the Commonwealth. By far, our largest office is here in Boston. But we also have offices in New Bedford, Springfield, and Worcester. And I think many divisions have sort of presences in multiple offices. So civil rights, for instance, we have personnel who live in both Springfield and Worcester as well. So let's move to the substance of things for the LGBT rights portion of the presentation. So as I mentioned, we're going to sort of go over a variety of protections that exist for LGBT people. And one of sort of the most directly applicable to sort of everyone's everyday life are protections in public accommodations. Public accommodations are defined by statute to basically mean any place that is open to and accepts or solicits patronage of members of the public. That includes sort of obvious things like restaurants, bars, healthcare facilities, childcare centers, parks, transportation. It can include like government-owned public facilities as well, libraries, things like that. And it also is not limited exclusively to physical locations. Businesses that provide services that are open to the public and solicit public business are still public accommodations, even if they don't sort of have people walking in the door necessarily. So one sort of common example of that kind of public accommodation is an insurance company. They have to provide services without regard to discrimination or without discriminating. Under the Massachusetts Public Accommodation Statute, which is Chapter 272, Sections 92A and 98, places of public accommodation are prohibited from discriminating against, harassing, or providing different or inferior service to an individual based on a large array of protected characteristics, a lot of sort of the obvious ones you'd expect: race, gender, religion. Relevant to today, they're forbidden from providing this differential service on the basis of a patron's sexual orientation or gender identity. And this can include a lot of different kinds of activities. It doesn't necessarily have to mean like kicking someone out of the store. It can be any kind of differential service is prohibited. For the LGBT community in particular, one area where this comes up where this issue gets discussed fairly frequently is with respect to restroom use, because public accommodations usually often have bathrooms open to the public, and for gender nonconforming or transgender people, there are questions about what bathrooms they are allowed to use. Massachusetts law provides that all people may use whichever gender-specific facilities are most consistent with their gender identity. And this has been the law in Massachusetts for close to a decade. And we want to make very clear, too, that this does not allow individuals to gain access to a sex-segregated facility that is not consistent with their gender identity. So you can't sort of enter a sex-segregated facility for an improper purpose or anything like that. Nor does it protect anyone who engages in unlawful conduct in such a facility, regardless of their gender identity. So people who sort of push back against equal bathroom access often do so on the basis that saying that there could be harassment or things like that. But harassment is forbidden in the restroom, regardless of whether you are in the correct one or the wrong one. So the law guarantees that people have access to the restrooms that they feel most comfortable using. And we also, whenever we give this presentation, we like to underscore that over the past 10 or so years that this has been the law, instances and reports of improper or unlawful conduct in bathrooms or locker rooms are incredibly rare. Like we never hear problems about people creating trouble for other patrons using the bathroom. To the extent people point to that as something justifying preventing people from using the appropriate restroom, then that's not something that's really borne out in practice. So moving on to public schools. So public schools are technically not a public accommodation, but they are covered by other anti-discrimination statutes and have the same anti-discrimination obligations under law that many public accommodations do. Saliently to this particular presentation, public schools are not allowed to discriminate based on sexual orientation or gender identity. And in particular, the statewide anti-bullying law at Chapter 71, Section 72O, ensures that all public schools protect students from all forms of bullying, including but not limited to physical violence, verbal attacks, and cyberbullying. There's a variety of programs that of various parts of the state government offer to help sort of further this rule and to help combat anti-LGBT bullying or hate or bias in schools. One, for example, the Department of Elementary and Secondary Education and the Massachusetts Commission on LGBTQ plus Youth have a Safe Schools program, which offers services to ensure that schools have sort of the right infrastructure that they need to implement anti-bullying laws and anti-discrimination laws, and helps make sure that practices are standardized across the state to create a safer and inclusive environment for LGBT students. My office, we have the Children's Justice Unit, which is sort of a subsidiary unit of the Civil Rights Division. They offer fairly regular training to schools regarding athletics, teaching schools how to combat bias and hate in school sports, which is something that has historically been a bit of an issue, but I think is on the decline thanks to these trainings. So in addition to public accommodations, there are protections for LGBTQ people and many other protected characteristics in housing. State and federal law both prohibit discrimination in the rental or sale of housing by landlords, property managers and owners, mortgage lenders, and real estate agents. Housing authorities are not allowed to refuse to rent or to ask a higher rent of tenants or prospective tenants based on their membership in any historically marginalized community, including but not limited to the LGBTQ community. Similar to the public accommodations law, there is sort of a wide array of protected characteristics where discrimination on that basis is forbidden by the housing statute. In particular, housing authorities also are required to honor a tenant's request for a reasonable accommodation based on their membership in a protected class. This is often connected to disability discrimination. My office does, and my division in particular, do a lot of reasonable accommodation housing related work. But we do see sort of a wide array of housing cases, sometimes including discrimination on the basis of sexual orientation or gender identity. But that is forbidden. Similarly, there are employment protections available. So state law, Chapter 151B, Section 4, prohibits refusal to hire an individual based on their gender identity and or sexual orientation. This is actually, it's the same statute that forbids employment discrimination as well as housing discrimination. It's just like it's like pages and pages and pages long, this one particular chapter and section that lists it has a long list of prohibited discriminatory activities, but it covers both housing discrimination and employment discrimination. And for employment purposes in particular, it's prohibited to refuse to hire somebody on the basis of a protected characteristic like gender identity or sexual orientation. It also prohibits firing people on that basis or other sort of differential treatment on that basis, adverse treatment, I should say. And it mandates that employers should arrange reasonable accommodations for employees who request such accommodations. This has sort of evolved a little bit over time. It started in 2011 with Governor Patrick, who implemented Executive Order 526, which prohibited discrimination based on gender identity and expression in state employment. And then in 2012, the statutory prohibition on employment discrimination was amended to include discrimination against LGBTQ plus people in both public and private employment. So moving on, for same-sex marriage, this is thankfully not something that has been sort of as much at the forefront lately. Massachusetts, as I'm sure many of you know, was the first state in the union to allow same-sex couples to marry, and that dates back to 2003 with the Goodrich decision issued by the Supreme Judicial Court. Following that judicial decision, the state statutory scheme for marriage was amended, and Chapter 207 says that the same laws and procedures that govern opposite-sex marriage also apply to same-sex marriages. So there are no special procedures, no differences. Just two people show up at the city hall, registry office, whatever, and can have the same access to marriage, regardless of whether they are a same-sex or opposite-sex couple. State law also permits same-sex residents of other states to get married in Massachusetts, following the same customary procedures as people who are residents here. And certainly this is not unique to Massachusetts anymore. It is 10 years ago, just a couple weeks ago, actually, was the anniversary of the Obergefell v. Hodges decision from the Supreme Court, the U.S. Supreme Court, which held that same-sex couples do have the right to marry under federal law as well. Because in the wake of that decision, Congress passed the Respect for Marriage Act, which I believe was 2022, maybe. That even in the event that Obergefell gets overturned and the Supreme Court, I mean, knock on wood, hope it doesn't happen, holds that there's no longer a constitutional right to same-sex marriage, the Respect for Marriage Act passed by the U.S. Congress ensures that a validly performed same-sex marriage under state law will be recognized, or has to be recognized in every state. So that ensures that there's some portability there. One issue that's particularly salient for LGBTQ people and for trans people in particular are gender and name changes on state-issued ID documents. For state ID documents, under Chapter 90, Section 8N of the General Laws, individuals are allowed to designate their gender as X, M, or F on a driver's license, permit, ID card, or liquor license. And individuals can also change their name to one that accurately reflects their gender identity. There is no sort of special requirement of what must be shown to change your gender marker on your license. There are some states, I think, that require a diagnosis of gender dysphoria. I don't know if there are any at the moment that have this, but historically there have at least been some that require like full surgery to as part of a transition to change your gender marker, and that's not the case in Massachusetts. You basically just need to make the request and it can be changed. And pretty much the only thing you need to do is just go to the RMV and make the request, have a new photo taken, and sign, and that's basically all you need to do. For birth certificates, it's a fairly similar process. Chapter 46, Section 13E of the General Laws, any legal adult, emancipated minor, or parent or guardian of a minor can request to change the sex designation on their birth certificate, again, to XMF or something else, without any kind of accompanying medical documentation or court order or anything like that. You could just ask. Another thing that's particularly relevant to sort of the news today is access to gender-affirming care. So gender-affirming care is an umbrella term that encompasses a wide array of care and services for medical health, behavioral health, mental health, surgery, psychiatry, therapeutic health, diagnostics, you can see the slide here. Basically a whole suite of services and care relating to the treatment of gender dysphoria, which for people who aren't familiar is sort of the experience of distress that arises from someone's gender identity not being in alignment with their sex assigned at birth. And this can include a variety of treatments. It can include hormone therapy, it can include surgery, but it also can include things that sort of are less intense than those options. It can include things like voice coaching, it can include behavioral health, it can like electrolysis, things like that. And the law protects access to gender-affirming care in Massachusetts. And the law, similarly, as part of our SHIELD law, protects healthcare providers in Massachusetts and patients in Massachusetts who are receiving gender-affirming care within the Commonwealth from lawsuits from out-of-state jurisdictions that may restrict gender-affirming care. This is something that I think is especially relevant in the past month or so because the U.S. Supreme Court issued its decision in a case called U.S. versus Skrmetti, which was a challenge on basically the equal protection basis to Tennessee's ban on gender-affirming care for minors, and the U.S. Supreme Court held that that ban was constitutional. The ban had been challenged as a form of sex discrimination, and thus such that it would be subject to a form of heightened scrutiny. But the Supreme Court held that the ban was not, in fact, sex discrimination, and they declined to address the question of whether it constituted discrimination against trans people and whether that thus in turn required additional scrutiny. So it was certainly an unfortunate decision, and it's one that will create complications for care for a lot of people in other states that have chosen to restrict this care. But in Massachusetts, access to gender-affirming care is protected. And so it's something that we're working very hard to make sure people still have access to. Similarly, state law protects access to reproductive health care, which includes sort of the same suite of services relating to pregnancy, contraception, miscarriage management, or abortion. And again, with our SHIELD law, that protects providers and patients who are providing or receiving that care in the Commonwealth from liability in lawsuits coming from out of state in states that restrict that kind of care. One thing that we get a lot of questions about is gender-affirming care and health insurance. So you might recall earlier I mentioned that insurance companies are a public accommodation, and one sort of consequence of that, sort of as interpreted by our division of insurance and courts and things like that, is that insurance companies are not allowed to discriminate on the basis of gender identity, which means that that if a service is covered under health insurance for sort of a non-gender dysphoria or transgender identity related reason, it has to be covered for the gender identity or transition related reason as well. So you can't exclude a treatment based on its association with queer or trans individuals, and you can't exclude treatment because it is being offered for gender dysphoria. So basically, as long as if a treatment is considered medically necessary for a patient, and gender-affirming care is often deemed medically necessary by providers, that treatment can't be denied based on the individual's gender identity or because the services are being used in the treatment of gender dysphoria. And restrictions on gender-affirming care places these individuals at a heightened risk for poor physical and mental health outcomes. For public insurance, MassHealth does cover an array of gender-affirming care, including some surgeries, hormone replacement therapy, and more. Eligibility for those procedures is very contingent on sort of a case-by-case assessment, and it's sort of up to the patient and their doctor. So it's not something that they necessarily like fling the doors open, but it's something that's covered. MassHealth will cover gender-affirming surgery if the member seeking the procedure has received a diagnosis of gender dysphoria from a licensed provider for at least 6 months and has submitted sort of a request for prior authorization. MassHealth also covers outpatient therapeutic and behavioral health services, as well as guidance from behavioral health providers who can help diagnose and support individuals with gender dysphoria. So basically, the gist of this slide is that gender-affirming care is protected under state law, both for private insurers and for public insurance with MassHealth. The one kind of wrinkle to that is for employer-funded plans. So plans where an employer basically provides its own insurance for its employees. Those are treated under sort of a different legal regime. They're not subject to state law. They're treated instead as subject to the federal law governing sort of employee benefits and retirement pensions. ERISA is the name of the statute, and I wish I could remember what it stands for. And so they're subject to a slightly different regime, and the way that that law gets interpreted is kind of in flux. So it's harder to say what kind of coverage is mandatory and what kind of discrimination is forbidden in sort of that one limited circumstance where there's an employer-funded health insurance option. But as a general matter, gender-affirming care is protected and must be covered by insurance in the Commonwealth. So looking forward, the federal landscape, as I'm sure will surprise nobody, there have been a lot of threats to LGBT identity and healthcare and things like that over the past 6 months or so. And there are sort of an array of actions that are being taken to help combat that and to help protect the rights of LGBT people in the Commonwealth and around the country. The AGO remains extremely committed to fighting for these protections. We, for instance, are working really hard to protect access to gender-affirming care. That's a huge part of what I do. That's going to be like my entire afternoon today, is working on getting sort of prepared to fight against efforts by the federal government to try to intimidate providers of gender-affirming care out of the marketplace for healthcare. Our office has also worked together with a lot of other sort of similarly minded attorneys general to file an amicus brief blocking implementation of the executive order banning trans people from serving in the military. And we've similarly provided a lot of guidance working with other attorneys general to get guidance to businesses and organizations in instituting DEI and accessibility policies to ensure protection for LGBTQ people in the workplace. I know we had also mentioned DA Ryan mentioned at the start of the presentation that I would talk a little bit about schools. I think another sort of federal landscape issue that has arisen in the last couple of weeks is the decision concerning the inclusion of LGBT content in school curriculums. And the Supreme Court decision basically said that the parents challenging this particular use of a storybook in a curriculum, they have to be given a chance to opt out of having their child be taught that, but it certainly doesn't give any parents any veto rights over whether those materials can be taught at all. It's just a sort of an opt-out. And it solely addresses sort of parents' sort of genuinely held religious beliefs and their ability to sort of shepherd the religious upbringing of their own child. But the decision doesn't place any restrictions on our ability as a Commonwealth to include inclusive materials in school curricula. And so that's something that I think schools around the Commonwealth should feel very free to do. So that's basically the end of the substantive part of the conversation and presentation. And so at the end of this, we just wanted to include some contact information. This is the AGO's website and phone number. A big part of how we find out about issues that are facing people in the Commonwealth is if people file complaints with us. So we have our complaint line here. There's the consumer complaint link. And here is, did the presentation, did it end? There we go. We have sort of a consumer hotline. We have sort of specialized hotlines for various issues, labor, civil rights, healthcare, insurance. There's dedicated intake personnel who are there to help process complaints and make sure that they are sort of addressed in the appropriate way. But I think the 10,000-foot view of the presentation is that Massachusetts remains a place where LGBT rights are taken very seriously, and the AGO really stands firm in trying our best to protect these rights as much as we can. Are there any questions?
We have a question in the chat. Can you speak about Orr v. Trump and the injunction?
Which I've lost track of which case names go with which. Orr v. Trump is.
Fran, do you want to climb off mute and clarify?
Oh, I see. This is
the gender marker.
Passports for gender markers. Yes. So the last I have heard about it is, during the Biden administration, the rules were set that you could basically change your gender marker on your passport, similarly to the way you can under state law, where you don't need documentation. You basically just need to make a request, and that rule was changed during the current administration. And there was this lawsuit filed, Orr v. Trump, seeking an injunction against that. My understanding is, the last I've heard about it is that Judge Kobik on DMAS issued an injunction prohibiting the implementation of that rule nationwide. So the I believe the current status is that people should be able to uh, uh, change the markers on their passports. I believe that that's not affected by the recent sort of national injunction prohibition that came in the birthright citizenship case. I think because this, if I'm remembering correctly, was done as a class action instead. So it's preliminary relief, so the case isn't over. But this is the rule, at least as it should be right now, is that people should be able to change their passport markers. I know I have heard some reports of there being problems with that in a few places where people who are supposed to be processing these requests to change the markers were sort of dragging their feet a little bit because they were waiting for guidance from the Department of State. But I haven't heard any updates on that in a couple of weeks, so I don't know.
Adam, okay, you see that other question, how the Medicaid cutbacks impact Mass Health's coverage of gender affirming care?
So the Medicaid cutbacks as part of the recent budget bill, to my knowledge, they will not affect what kind of procedures are covered by Mass Health. My understanding is that the new bill largely just covers who is eligible for Medicaid and not what Medicaid has to cover. And so Medicaid also, the way it works, it leaves a lot of what is covered to state discretion. And so I think as long as Massachusetts remains committed to providing this care, it should, for the time being, still be covered by Mass Health. There is the possibility, based on very early in the current presidential term, President Trump issued an executive order directing that the Department of Health and Human Services and the Centers for Medicaid and Medicare Services issue rules restricting the ability of Medicare and Medicaid to pay for gender-affirming care, for minors in particular, but I think maybe for adults as well. That rule has not come to pass yet. So for the time being, certainly, Medicare and Medicaid continue to cover gender-affirming care. And even with the statements that have been coming out of the federal government suggesting that they're going to try to restrict that, I know for a fact payments are still going through. And then as for what happens down the line when they do eventually try to comply with this directive from President Trump and the executive order, I'm certain it will be the subject of litigation, and I think we will certainly fight as hard as we can to ensure that that the services remain covered. But for the time being, Mass Health continues to cover gender-affirming care is the bottom line. And finally, does state law provide a cause of action for people who are constantly misgendered? I don't know if there is a cause of action that is specific to that. I think that there is a statute that the Massachusetts MCRA, Massachusetts Civil Rights Act, I think is what it's called, that provides sort of a private cause of action to people that they can use if they're being sort of harassed or intimidated or coerced. I think those are it's in intimidation, coercion. There's one other standard that sort of in contravention of a right that's secured by some other statute. So I think depending on sort of the pervasiveness and intensity of the harassment and misgendering, there could conceivably be a cause of action there. But it's obviously extremely circumstance dependent, and it would be irresponsible of me to sort of say anything sort of more specific than that. That's the closest thing I can think of to an answer to that question. But I hope that's helpful. Are there any other questions in the chat before I pass things over to the other presenters?
Questions, comments?
Oh.
Thank you so much. That was really helpful.
Great. Thank you so much for having me. Let me away and my
Really very helpful.
and
So,
thanks everybody.
thank you. All right, before we turn to our next presenters, I just want to point out, I spoke a little bit at the beginning about the legislation we've been working on, and so many things that we are able to accomplish, certainly in this county, are as a result of our partnership with our legislatures. And I particularly want to welcome Representative Lewis, who's here with us. He's here so often with us for these meetings. He's been a great partner on these issues. So I'm glad to see you on this rainy day. Thanks for being here. I'm going to turn it over now to Laura Sinelli and Alexis Leon from the Rennie Center for Education Research and Policy. And they're going to talk about how Massachusetts is responding to federal changes and supporting schools and communities in particular. I talked a little bit at the beginning about that editorial this morning at the Globe. And let me tell you a little bit about them. Laura comes to the Rennie Center with a background in education policy and on-the-ground experience, both in a classroom and at the district level. She serves as the deputy director, and she oversees lots of the internal and external responsibilities of the center, whether it's budgeting and human resources inside to the board engagement and policy outreach. And she brings to that her experience having been the deputy chief of staff to the Boston Public Schools. A challenging job on its best day, where she worked closely with the school committee, advancing the district's policymaking, managing projects, including working on school quality. She's a graduate of Georgetown Law School, and where she participated in a policy clinic of the Harris Institute for Public Law, and served as an intern in the Education Policy Office of the Senate Committee on Health, Education, Labor, and Pensions. And she went to law school having taught fourth grade at an elementary school in Las Vegas, and earned a master's degree in education from the University of Nevada in Las Vegas. So she's got both that literally on the ground in the classroom, having seen how policy is made, having come to Boston, which I think we'd all agree, the Boston schools balance lots of complicated issues, and then coming to this job. So wealth of experience for us. And Alexis joined the Rennie Center with a background in education policy as well. She is the policy director and leverages the findings and the lessons that the center has gathered from its research and on the ground initiatives to help develop that policy agenda, to really focus on systemic changes that will improve Massachusetts education. Alexis served in several capacities with the Massachusetts Executive Office of Education. She supported the Boston Public Schools Central Office redesign and restructure. And like Laura, began as an English teacher in Baltimore in an alternative school, which served 18 to 21-year-olds. And she is also a board member of a local nonprofit, which supports prison education by coordinating teams of volunteers who mentor men and women who are incarcerated and pursuing higher education. She has a bachelor's in policy studies and political science from Syracuse and a master's in education from Johns Hopkins University in secondary education, as well as a second master's from the Harvard Graduate School of Education. So thank you both for being with us this morning.
Great. Thank you so much, DA Ryan, for the introductions and for the opportunity to be here to share more. Given the nature of our discussion today, I won't say we're excited to be here to present to you. In some ways, I wish we didn't have to be here to present to you about some of these topics, but certainly hope to be a resource for you both today and ongoing on an ongoing basis in the future if there are any questions that come out of this conversation. So Alexis, thanks for screen sharing. My computer sometimes doesn't like it when I do, so you're going to be in charge of moving slides forward. Can you go on to the next one? I think it's just intros. Yep, so this is us again. You know us, just heard all about us. So the Rennie Center, just to give you all a little bit more background about who we are and what we do as an organization, our full name, Rennie Center for Education Research and Policy, obviously gives you some indication of what we do. But just to kind of give a little bit of history or context about our work in general, So the Rennie Center was founded in 2005. We've been around for 20 years now by former Secretary of Education Paul Reville, really as an opportunity to serve as an independent, impartial source of information on the education system in Massachusetts. And when we were founded, we were really intended to be primarily a kind of a traditional think tank. So putting out research reports, inviting people to come and hear about the results of those and comment on them. And we still do have a very active research portfolio that looks at a variety of issues and topics from around Massachusetts education and beyond. We've also expanded over the last 12 years or so into what we call our practice work, which is us working directly with schools and districts to help think about how to put some of those research topics into practice. So helping build capacity of school and district educators, administrators, leaders to think about how to most effectively use evidence-based practices. And then our policy work really comes by taking what we learn from our research and what we learn from that on-the-ground practice work and translating that into lessons that will resonate with policymakers at the state and district levels, as well as at the federal level where relevant. So that's what we do at Rennie. We have kind of these three different parts to our work. Today, obviously, the focus will be very much on the policy piece of kind of what is the federal impact on education, what has been the impact of some recent executive orders in particular. Before we go into kind of the specifics on some of those, thought it would be helpful if you can go to the next slide, just to lay out a little bit of kind of general discussion around tactics that the administration is using. So I'm going to turn that over to Alexis to go through some of those.
Awesome. Thanks, Laura. It's great to be here. Thank you for having us today. So as Laura mentioned, I don't think much of what we'll discuss now will come as a surprise to folks on this call, but again, I think it's important to kind of lay a foundation before we hop right into some more wonky education topics. So at the federal level, we have seen a coordinated approach to reshaping education policy. These strategies are certainly not isolated actions. They're reflective of a systematic use of policy and executive authority to shift these priorities and governance structures. So some of the themes that you see here of the approach on the slide describe how some of those federal actions are influencing education systems across the country. So first, identifying cracks. So this is in reference to some of the federal actions targeting perceived vulnerabilities within education agencies and institutions. So for example, an executive order directed the U.S. Department of Ed to begin the process of closure, a proposed 50% reduction in staff. And while both efforts were paused by court action, they reflect this effort to test and kind of expose areas where systems might be susceptible to disruption or reorganization. Second, we've seen the strategic use of levers of control. So things like executive orders, funding changes, some regulatory guidance shifts have been used to change some of these federal priorities that Laura will speak to in just a moment. Limiting support for things like DEIA initiatives while expanding focus more on things like school choice or parental rights. These tools have allowed for some significant policy shifts without requiring new legislation, for example. A third term that I'm sure a lot of us on the call have heard before is flood the zone. So this is in reference to this high volume of directives, particularly in the first 100 days or so of the administration, introduced in very rapid succession, can overwhelm states, school districts, and academic institutions. This includes guidance from multiple federal agencies, enforcement communications involving changing compliance expectations, and it can just create operational and legal uncertainty. And finally, a term that we've used often internally to walk through this work is preemptive overcompliance. So in response to this really rapidly changing environment, some schools and universities have scaled back or paused DEIA programs, even in the absence of some sort of legal mandate, to avoid scrutiny or a risk to their federal funding. So this dynamic we've seen can have a real chilling effect, particularly when the boundaries of that compliance are relatively unclear. All right, so I'm going to pass it back to Laura with that broader context in mind to take maybe a closer look at how those strategies are being put into action aligned to the administration's priorities.
Yeah, so if those are some of the goals of the administration, the strategies that they've used specifically to accomplish those are, you can see at the top here, Well, three of the strategies at least are executive orders, funding cuts and freezes, as well as changes in legislation. So just to take those quickly one by one, executive orders, that's mostly what we're going to focus on today, put out by the president in quite a large number. I actually just double checked the numbers yesterday in preparation for this because I was curious. So the Trump administration through July 7th, aka this past Monday, has issued 170 executive orders. For comparison, the Biden administration over 4 years, there were only 162. So they've actually issued more already since January than the Biden administration did in its entire 4 years. The Obama administration, which of course had double the amount of time as the Biden administration, issued 276. So we are on track to shatter that number if it keeps going at the same pace. That included 26 executive orders issued just on the first day of the administration alone. So a huge number coming out, kind of to that, speaking to that flood the zone strategy of just putting out all of the information and all of the priorities, like very publicly, in a very public way, and a very easily, I guess, observable way, what the administration is hoping to accomplish. The second piece, funding cuts and freezes. This includes both, obviously, the DOGE cuts that have made a lot of headlines. In terms of education, some of the impacts there have been $900 million in DOGE cuts to the Institute for Education Science, or Institute of Education Sciences, for research grants, as well as there were non-continuation of more than $1 billion worth of school mental health grants that were frozen by the administration. They also froze over $2 billion in research grants to Harvard, in keeping with the kind of the ongoing back and forth between those two institutions. Most recently, you might have seen the news, there was a nationwide $6.2 billion in congressionally appropriated funding that was frozen, that was supposed to go to schools for things like out-of-school time programming, migrant education, and grants to support English language acquisition. So those are not necessarily cut, but they are currently on hold. And that includes $108 million that was supposed to come to Massachusetts to support programming this summer and beyond. So beyond those two, while the administration itself certainly is not responsible for legislation, it has been a significant influence in the process of supporting changes in legislation, particularly the budget reconciliation bill that just passed last week and was signed into law. And that also, of course, has a number of effects on education, both indirectly through programs that will impact school funding, such as Medicaid or SNAP, as well as some direct changes to education policies, such as a new federal tax credit around school choice, as well as some changes to student loan forgiveness programs. So in all of those different ways, the administration has been kind of working actively to advance its priorities, some of which include, as you see here, eliminating the U.S. Department of Education, that's USED, ending what it would consider illegal diversity, equity, inclusion, and accessibility, or DEI, DEIA activities. We'll definitely talk more about that piece later on when it comes to some of the executive orders. There's also the priority of just generally reducing the federal footprint over public education, and particularly by reducing federal funding, expanding private and school choice, and disrupting higher education through a number of different ways, including by disrupting grants for research and data collection, as we talked about with Harvard. So lots of different priorities that we could cover. We won't have time to go through all of those today. So we're going to zero in on 3 particular executive orders that have come out that have kind of a larger, wide-ranging impact. And then we'll highlight just a few others. And just to put this out there early on in the presentation, so if anyone can follow along if you're curious, the Rennie Center has put out an explainer trying to summarize and synthesize some of the takeaways on these different executive orders, both the ones we'll talk about in detail, as well as some of the other ones we'll reference more quickly. So if anyone is interested in checking that out, either during today's presentation or beyond, that's linked in the chat. So over to you, Alexis.
Awesome. Thanks, Laura. All right. So as Laura mentioned, we'll go through 3 executive orders today, but if you have other questions about others listed on the link that Laura just sent out, we'll have our contact information here, and please feel free to reach out with any other questions. All right. So the first executive order that we'll take a look at today was released in January, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. So this order directs all federal agencies and any contractors or grantees to eliminate DEI programs in their hiring and contracting practices. It prohibits consideration of race, gender, or sexual orientation. And in addition, instructs the U.S. Department of Education to issue new guidance to colleges and universities regarding racial preferences, especially in light of the Supreme Court's 2023 decision ending race-conscious admissions. So this order doesn't just affect hiring and employment, it also has real implications for higher education policy. Not surprisingly, these changes have sparked a number of legal challenges. For example, the National Association of Diversity Officers in Higher Education filed a lawsuit arguing that this order violates First Amendment protections and congressional authority. A separate class action lawsuit came from federal employees who were dismissed due to their involvement with some DEI work, and they claim that those firings violated free speech rights. Some courts have stepped in, at least temporarily, blocking parts of the order. These rulings have certainly paused certain provisions affecting both federal employees and DEI-related efforts in K-12 schools. But as you'll probably hear from us a bunch today, the legal landscape remains complex and changing rather rapidly. A recent Supreme Court decision, as Adam referenced earlier, Trump versus Casa, the birthright citizenship case, might limit how broadly these injunctions can be applied in the future, potentially restricting the ability of lower courts to block those federal directives more nationwide. So in Massachusetts, we have seen vocal opposition to this executive order. Back in February, Governor Healy and Attorney General Campbell issued joint guidance to our educational institutions, reaffirming the state's commitment to DEIA in both K-12 institutions as well as higher education. And their message was clear: right? Continue this work, but ensure that it aligns within current legal standards. In June, a federal judge ruled that the administration's cancellation of those NIH research grants related to LGBTQ+ and DEI issues was illegal and discriminatory. That ruling followed lawsuits brought by public health groups and 16 states challenging cuts totaling nearly $2 billion. And finally, Massachusetts universities and K-12 institutions are navigating this order in varied ways. Some we've seen push back really strongly, vocally and publicly. Others we've seen are taking a bit more cautious approach, especially those that rely heavily on federal research funding, specifically from agencies like the National Science Foundation. All right, I'll pass it to Laura for our next EO.
Yes, so the next order to talk about came just about 8 days after the last one that Alexis was describing, and this one is on, quote, ending radical indoctrination in K-12 schooling. There's a lot here in this order and kind of the implications of it and what it means, so I think it might be helpful just to kind of zero in on two key concepts to help understand what this means and what this does. The first of those key concepts is definition, and the second is chilling effect. We already mentioned that term once, but we'll come back to it again in discussing the effects of this one. So what I mean by definitions is that a key part of this executive order is defining what the Trump administration sees as anti-discrimination under existing federal law, particularly Title VI of the Civil Rights Act, which prohibits racial discrimination in federally funded programming, and Title IX, which prohibits discrimination on the basis of sex. So they're essentially putting into law, or putting into this executive order, their definitions of what that anti-discrimination means. In particular, they use the term discriminatory equity ideology to say that that violates anti-discrimination laws, and that includes any ideology that would treat an individual as a member of either a preferred or disfavored group rather than an individual. It also includes the concept that the United States is inherently or systemically racist. So they would consider that as violating anti-discrimination laws to include to teach any matter that it includes those sorts of concepts. Similarly, the order defines gender ideology as also violating anti-discrimination laws. That means, in their terms, gender ideology would be replacing the biological category of sex with a concept of self-assessed gender identity, and includes the idea that there's a vast spectrum of genders that are disconnected from one's biological or birth-assigned sex. So having established those definitions, basically saying this is what we believe anti-discrimination law now means, the order seeks to ensure that any federal policies, and particularly federal funding decisions, are compliant with the administration's understanding of what anti-discrimination looks like in K-12 schools. Specifically, it calls on officials to develop this ending indoctrination strategy. Departments need to review any federal funding sources that would directly or indirectly support either this DEI or gender ideology as defined by the administration in K-12 curriculum, instruction, or programs. It also would look at whether any of those sorts of ideologies are present in teacher education, training, and licensing. So essentially, if the departments were to find that there were any federal funds used to indirectly or directly support this type of work, they would also then put forth a process to prevent or rescind federal funds from being used for those purposes. So basically, the purpose of the order is to seek to ensure that federal funding complies with what the administration is defining as legal and allowable under anti-discrimination law. A couple of other noteworthy provisions to mention. One, just quickly, on kind of the flip side, where they're saying, this, what they call discriminatory equity ideology or gender ideology would be not allowed. They are hoping to promote what they would term patriotic education, which is essentially kind of a positive view of American history, that the country has promoted noble ideals throughout its time. And it creates this, what's called a 1776 commission that was first founded under Trump's initial term to promote this idea of patriotic education. Also, there is a provision in the executive order that relates to the concept of what they call social transition. And this would be any activities taken to facilitate the non-medical, but rather the kind of social transition of genders. So anything from using a different name for a student, using different pronouns for a student, allowing students to use school facilities that match their gender identity. And there is actually in the executive order a direction for the Attorney General, the U.S. Attorney General, to coordinate with state attorney generals and local DAs to facilitate the prosecution of any teacher or school staff member who unlawfully facilitates the social transition of students. This, by the way, has not been tested or applied kind of legally, to my knowledge at least. Certainly there has not been any litigation that I'm aware of that's dealt with this specific provision, but that is in the bill to look at kind of individual actions that can be taken in cases where there is a social transition happening. So that was all, I would say, kind of that first key concept around definition, that's the main purpose of this executive order, is to define what they mean by anti-discrimination. The second key concept I mentioned is chilling effect. And that honestly is the main effect that this order is likely to have. Any sort of attempt to enforce this order legally would very quickly run up against significant legal hurdles, among them protections of free speech, protections under the Equal Protection Clause of the 14th Amendment. And then there's actually also specific provisions within several pieces of legislation, most notably from the 2015 Every Student Succeeds Act, that prohibits the federal government from interfering with curriculum decisions at the local and school levels. So there are a lot of barriers from the government being able to do a lot of the things that they've laid out here. Also, enforcement would of anything that they put in place here under this order would need to go through the Office for Civil Rights, which would have to find evidence of a violation, give the offender time to correct the violation, and then only if not corrected could they actually take action, such as holding back, withholding, or rescinding federal funding. But the real force of the order isn't about its legal standing. It's from the impact it's likely to have on state, local, school, and even individual teacher decisions. Already we had seen that as of late 2024, about 21 states had laws in place targeting curriculum related to what they would consider divisive concepts like gender and race. And a survey from last year shows that almost 2/3 of public school teachers have already opted to limit their instruction on political or social issues because of these policies or community pressures. So we're already seeing this chilling effect take place. This order is likely to embolden states that are either seeking to pass or enforce similar measures. Just a quick note on the legal challenges part. So as I mentioned, these legal challenges don't relate to the order itself, but the U.S. Department of Ed has put out some other resources or other information seeking to kind of further advance this definition of what it means by, or what it holds to be anti-discrimination law. And there have been some court injunctions around that. So an order on April 24th, there were a few different decisions. One blocked the enforcement of a letter from February, which stated that the department would enforce compliance with this interpretation of anti-discrimination law. Another order, the department had asked states to certify that they're not using, quote, illegal DEI practices. And another court order, also from April 24th, blocked that certification process from going forward. Not before 21 states had actually already certified that they would, or signaled that they would sign the certification. Massachusetts was not one of them. They had already signaled their intent to decline to certify this compliance, but at this point, it's a moot point because there has been that injunction on the certification process in general. So if you go forward, not really a whole lot to add in terms of how Massachusetts has responded compared to what Alexis shared for the last one. As she mentioned, the governor and the attorney general have reaffirmed their commitment to DEIA efforts in K-12 and higher ed. Local school districts have also put out similar statements reaffirming their support, as have the Department of Elementary and Secondary Education and Education Secretary Tutwiler in Massachusetts. So pretty much universal agreement across different levels and parts of state government that this is not something that they are inclined to preemptively comply with, but because of the chilling effect that I talked about, it's hard to say what effect there might be on individual teachers making decisions day to day about what they will cover in their schools and curriculum. So I'll stop there. Go on to you, Alexis, for the last one.
Great, thanks, Laura. All right, the third executive order we're going to highlight today, also issued in January, focuses on combating anti-Semitism with a particular emphasis on college campuses, but also has been frequently in the news for K-12 schools as well, as DA Ryan mentioned earlier in the call. So this order directs federal agencies to strengthen enforcement efforts by requiring detailed reports on the use of both civil and criminal legal tools to respond to anti-Semitic incidents. It mandates a comprehensive review of civil rights complaints related to anti-Semitism since October 7th, 2023, and calls for new guidance on how to handle cases where non-citizens are involved in an unlawful activity, raising the possibility of visa or deportation-related actions. The stated goal of the order is to ensure accountability in how institutions respond to anti-Semitism, but the implementation of this has raised some important questions. On the one hand, many see this as a necessary and forceful step to protect Jewish students and ensure that anti-Semitism is addressed with both urgency and seriousness. But on the other hand, many stakeholders, including civil rights advocates and higher education leaders, have voiced some significant concerns. While the order operates within existing legal frameworks, it has relied heavily on the threat of federal funding revocation as an enforcement mechanism, which has led to legal challenges and a lot of debate over its impact on both academic freedom and free speech. Several high-profile actions have drawn national attention related to this executive order. For example, the federal government has revoked $400 million in research grants from Columbia University, is currently reviewing up to $9 billion in federal funding to Harvard. And all of these actions have prompted lawsuits, have intensified conversations about the appropriate balance between enforcement and institutional autonomy. In Massachusetts, we have certainly seen this play out in pretty concrete ways. Harvard University has sued the federal government, arguing that the freeze on its research funding has violated the First Amendment and other proper legal procedures. In a separate but related development, a doctoral student at Tufts, Rumeysa Öztürk, was detained by immigration officials following a pro-Palestinian speech, drawing significant attention from several Massachusetts lawmakers, and has raised some broader concerns about just free expression and federal action targeting international students. The Federal Task Force to Combat Anti-Semitism visited Boston in April as a part of a national effort to meet with city officials to investigate how cities, schools, and campuses are responding to anti-Semitism and whether or not further intervention is needed from their perspective. And so while this order is framed around civil rights enforcement, we've seen the ripple effects touch on issues that are really central to this task force. So namely how Massachusetts can support student safety, uphold free expression, and respond consistently and equitably to bias and hate in all its forms. All right, I will pass it back to Laura. I know our time is short and we have a lot we could talk about, so I'll pass it back to Laura to share a little bit more of some of the other EOs that we seek to analyze.
Yeah, so mostly I'll just direct you back to the document that I linked in the chat if you want to learn more about these or others. But just to give you a quick overview or flavor of what else was in some of the other executive orders that the administration has put out. The first one on there, expanding educational freedom and opportunity for families. This one is related to school choice. So basically directing agencies to review how existing funds could be used to expand educational choice. It only directly applies to those educational systems that the federal government runs itself. So Department of Defense runs schools and Bureau of Indian Education schools would be the two there, but indirectly could have broader impacts if there's funding streams that are now channeled to support school choice initiatives. The second one, keeping men out of women's sports. states that educational institutions must restrict participation in women's sports to individuals whose sex at birth is assigned as female. Failure to comply, as again, sort of similar to the other one that I was talking about, could result in educations losing federal funding, subject to investigation under Title IX. The third one, improving education outcomes by empowering parents, states, and communities. A little hard to parse out from the name what this one means, but this one you can think of as the order that aims to essentially shut down to the maximum degree possible the Department of Education. So it directs the Secretary of Education to take necessary steps to the maximum extent permitted by law to close the department. And there have been lots of legal battles over the administration's powers to lay off federal workers. So not totally resolved. In May, there was a Boston-based federal judge who halted the enforcement of this particular executive order, including by ordering the reinstatement of around 1,400 federal laid-off U.S. Department of Education workers. But as you may have seen just a couple days ago, the Supreme Court also issued a brief order saying that the Trump administration can likely do what it wants when it comes to the federal workforce. So it lifted a separate injunction different from that one that had been placed on federal layoffs. So unclear what will happen eventually, but certainly aligned with the administration's stated priority to close the U.S. Department of Ed. And then the last one on there, reforming accreditation to strengthen higher education, directs the Department of Ed to hold accreditors accountable if they enforce what they consider DEI-based accreditation standards. And actually, just while we were in this meeting, I got a news alert from Boston Globe talking about accreditation as a often overlooked, but very powerful or very influential tool in the higher education arsenal. So definitely worth taking a look at if you're interested in higher ed issues. So lots more on the page that I linked. Just wanted to give a quick overview of, recognizing that some of these other issues have also been the focus of other executive orders. But with that, Alexis and I are happy to take questions with the caveat that we are not able to give kind of direct legal advice about any of these orders or how they might impact individuals. But we're certainly happy to answer questions that come up more on the policy side of things, either today or in the future. So thank you all for your time.
Thank you both. That was a lot of material that you covered really well in a short period. Questions, comments? Antonia.
Yeah, Laura, can you clarify the 2/3 of teachers that were surveyed? Was that just a Massachusetts survey or a national survey of the teachers? And was it specific to they had their own choice to control what they were teaching in their class? Or was that going to be trumped by the school district that was saying, we're going to stay true to what we believe?
So it was that was a national survey. It was done by the Rand Corporation. I actually had the link to the article there, so you can read more about it if you're curious. But yeah, basically saying that teachers were choosing to monitor or limit their discussion of potentially controversial issues because of their concerns about what the implications might be.
And my last question is, as I'm listening to you, I'm trying to figure out, well, so if they're going to get rid of the Department of Ed, then you're not going to be able to kind of investigate and look at these civil rights violations. Or, I mean, I'm assuming that they understand that, or maybe they'll carve out that one group to govern this. Am I thinking of that correctly? Or is it that some other part of a federal agency that's still intact is going to be overlooking the?
To my understanding, I think you're reading the situation exactly right, which is they are simultaneously reducing the workforce in the Office for Civil Rights and trying to impart their own priorities for what that office would investigate. There's obviously some tension there, which I think you've highlighted well. I think that goes back to the point around the chilling effect, that part of what they're hoping to accomplish with all these orders is not necessarily direct enforcement or compliance through the Office for Civil Rights, but rather hoping that people will just be more conscious about monitoring what they're putting out and what sort of programming or curriculum they're using, before any sort of compliance effort would come down.
Great,
Alexis,
thank
if you had anything else to add there, but yeah.
I have a question about the first order. So you talked about how it affects federal contracting and hiring. So could you just, and I think that you touched on this a little when you were talking about it, but so that sounds really broad. Do you have several, like, some examples you could give, like, schools that get grants, like who else is covered under that?
Yeah, that's a good question. Laura, please hop in here if you have some examples off the top of your head. I mean, I think the way, I guess if we're speaking from like just the Massachusetts perspective, from like K-12 schools, I think there's a lot of local control and autonomy that schools can kind of interpret this as they would hope in the way that they are hiring, staffing, creating offices of equity, however they're kind of naming conventions for some of those offices. So I think we've seen a lot of local schools and districts interpret this in the way that they choose is best to advance kind of the priorities and mission of their local communities. I don't know, Laura, do you have any federal examples? I don't have any that come to the top of my mind, at least like from an education lens, for how that would play out more specifically than a blanket, like any hiring of staff or any sort of initiative. I don't know, Laura, if you have anything that comes to mind.
Not like a specific program or contract I could point to. But yeah, I'm sure we could track down some examples. Nothing that comes to the top of my mind.
Okay, thank you.